If you're an independent RIA firm, should you be marketing estate planning? And what options are out there for you to do so? What this presentation does is it summarizes and updates some of the materials I've gathered in this area where there's not a lot of resources. I've given talks on this subject to some FPA chapters in my region, and I've got an article coming up in the April issue of Trust and Estates on this exact issue of how do you formalize the structures of marketing estate planning within an independent RIA firm, especially when the traditional silos of the practice of law require you to look at estate planning as a separate thing that you cannot touch. Now, what this presentation is about is the fact that wirehouse advisors often have their own back office estate planning services available, which they can market to clients and referral sources. However, independent RIA firms do not have these same resources. So, how does one fill that service gap? Now, as my own shameless plug, what this presentation is also about is that I'm building proof of concept to serve as a resource for independent RIA firms and any other wealth, legal, or tax advisor who wishes to market estate planning outside of a law firm. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. So today's episode 169, is all about marketing estate planning by an independent RIA firm. Now, even though there is no legal or tax advice really given in this presentation, I want to remind you that this presentation is not intended to substitute for legal or tax advice. This presentation also includes some marketing, which is not intended to serve as attorney marketing. And if you'd like a copy of these slides, please email me at griffin.bridgers@gmail.com. This will be one of many calls to action I set forth in this presentation. So, as I mentioned, I've given this presentation to some FPA chapters. And if you're interested in this as a presentation for your own FPA or chapter or estate planning council, that's my second call to action. Once again, email me at griffin.bridgers@gmail.com. But a good place to really start here in understanding this is to realize that, basic estate planning involves really three elements. One is educational. This is just teaching clients about their options and choices when it comes to tax, laws, asset protection, documents, all sorts of things, knowing what documents do and why they do what they do. There's another huge element that gets glossed over, and that's organization. So that's helping a client know what they have in place, summarizing existing estate plans, bringing together the financial and inheritance and even digital asset elements into that organizational arm. And then finally, this is where most attorneys come in, and that's the legal element, where you're drafting documents based on what happens in the education and organization levels, and then filing tax returns if needed to implement the estate plan as well. Now, what we're not going to discuss today is that there's a fourth element, psychology, where we've started to see this captured as an organized service offering, but it hasn't really yet trickled down from the ultra high net worth to the mass affluent type of market. Now, with all this being said, I was reluctant to put this out there. I've been slow in trickling this out because I'm the messenger, but anytime you challenge the status quo for attorneys or advisors, you tend to get people angry at you, saying, oh, you're trying to ruin my practice, you're trying to advocate ideas that are going to shut me down. All I want to remind you is that these are changes that are already happening. I'm just organizing what I've seen in the market. I'm not causing any of this, but you can't direct your anger at me. Just listen, because really what I'm going to do is show you the competitive forces that threaten the status quo. So if you're concerned at all about growing or maintaining your firm or successfully transitioning it in the near future, you will reach an inflection point where you may have to react to some of these market services and forces out there. So, that being said, the meat and bones of today's discussion are understanding two models where wealth advisors have formally captured estate planning services and begun to market them. Now, I mentioned at the beginning that wirehouse advisors, or advisors who are captive to a broker-dealer, sometimes even independent advisors, with certain custodians may have access to a knowledge team that serves on a regional or national level. Usually, individuals within this team will be known as wealth strategists or estate planning strategists. There's all sorts of permutations. And you can have both attorneys and non-attorneys serving on these teams, but the big crux of this team is that it fulfills two of the three estate planning elements we talked about: education and organization. Now, the legal element typically is not fulfilled by the strategist, especially because you have non-attorneys who sometimes supervise or operate on these teams. So the legal element still will require a referral to an outside attorney. But the education and organization elements are designed to streamline that referral. And we've seen some strategist teams also look at loosely attempting to create a system for vetting and recommending estate planning attorneys. In other words, kind of a closed referral system for their captive advisors. But attorneys who want to participate in that type of closed referral system should take care to begin with, because typically it's going to be biased not towards expertise, but more towards who is willing to take the advice and recommendations of the strategist sight unseen. So because of that, if you're an attorney looking to participate, there's a cost to doing so, and that cost could be a violation of your ethical duty of independent judgment. Now, the biggest thing I want you to remember here is that the strategist does not practice law and thus cannot fulfill the legal element. So especially for non-attorneys, they're constantly towing the line of at what point do you cross over into the unauthorized practice of law, and how do you avoid that? Now, today's discussion is not necessarily about the strategist model, but if you have this available, it's something that you should utilize if you are a wirehouse advisor. Now, since this is a cost center in most financial institutions, which does create value in other ways, there's a lot of independent RIA firms who don't have access to this type of regional shared resource because independent RIA firms are operating on their own. Now, sometimes your custodian might provide this, but oftentimes it's not available. So what I've seen in the market is that a number of independent RIA firms are seeking to create former or closer affiliations with estate planning attorneys, so that maybe you have an attorney under the same roof as the RIA, which is designed to create ease of referrals for drafting documents and funding estate plans and getting everything in place without having the need to refer externally and without having the need to have a client not follow up on estate planning recommendations. So what the attorney here does is fills all three elements: the legal, the education, and organization. Now, there's a lot of risks here, and I've seen a lot of RIAs jumping blindly into this type of arrangement, but this is something where it's driven more by optics than by function. Yeah, the function's great, but what the function does is it creates the optic that you're able to market estate planning and compete with other RIAs in the area who might not be offering this, or who might be larger and have the scale to offer this in an economically beneficial way. Now, there's many unforeseen risks in this model because it hasn't really been developed well outside of very, very large RIA aggregators or organically grown extremely large RIAs. So, is there a way to capture these optics without binding yourself to an attorney? Because by no means does this capture all the risks of this model, but there's a lot of elements you need to think of here that can really cause this type of relationship to run off the rails. For both sides, but especially the attorney, there's a lot of ethical risks in that. It's easy to run into issues with sharing of fees, conflicts of interest, loss of independent judgment, the question of when does representation begin. There's a lot of things that can go into this. From a business perspective as well, I think a lot of attorneys and advisors really underestimate the volume of business that's required to make this relationship successful. Attorneys, especially in the estate planning world, especially in this type of model, are really making their money off of just repeated estate plans and putting those into place. This tips the scales more in favor of estate planning over probate and litigation and business and some of these other affiliated practices, plural. So the attorney's required volume is going to be much higher than the volume of the RIA when you compare the two businesses. And at some point, the RIA's client base will be saturated, and it makes it hard to maintain the captive attorney relationship after that point. The business is going to dry up for the attorney at some point if the RIA is not constantly bringing in new clients. Then finally, liability is a huge area of exposure that's not anticipated. But when you affiliate, even if there is no co-ownership, the attorney and the RIA are opening each other up to cross liability for the other's errors. That risk can be economical in some ways, can also be a risk to your professional reputation. If you're sitting there, in this type of formal relationship, you're essentially by affiliation representing your confidence in the services of the other, and if those services fall short, then that's going to create egg on your face. So the golden rules here are really that, one, attorneys can't share fees with non-attorneys, and that a failed captive attorney relationship will hurt both the attorney and the RIA. So this is not something to rush into lightly. So the question is there a third model, or models plural, outside of the two that I described, the strategist and the captive attorney, that might serve independent RIA firms and estate planning practices? In other words, is there a business opportunity out there for attorneys and advisors to better join forces and provide all three elements of estate planning service? Now, I'm kind of premature in putting this out into the world, but I've seen a number of services pop up which have kind of given me a sense of urgency. And I'm not going to give them free advertising on my platform here, but they're designed to capture that organizational element, with estate plan reviews and things like that. And it falls short because, you get a pretty report maybe summarizing an estate plan, but it sticks the advisor with the educational element, which they may not have the knowledge to do. And a lot of these are tech startups where they're really seeking to capture the legal element in the future and compete with LegalZoom in a tech capacity. So you're going to see these services competing with the attorney, and also you're going to see tech startups that may be affiliated with a larger RIA who are going to have your client's info in estate planning documents. So this isn't necessarily a good solution too. You don't have attorney backing if you go through this type of organizational service. So really what I'm looking to do is say, hey, let's break down the silos of estate planning and wealth management, and maybe look at how can attorneys unbundle the education and organization elements and provide these at no or a lower cost to the RIA directly instead of to clients in a billable form. So with that being said, my shameless plug and my why here is that really I'm building proof of concept for this service model of how can independent RIAs market estate planning as a service offering, especially by capturing that education and organization elements, either with in-house talent or better affiliations with outside estate planning attorneys. So if you'd like to participate in that, please email me at griffin.bridgers@gmail.com, and also reach out if you want a speaker on these subjects for your FPA chapter, estate planning council, bar association, trade group, whatever the case might be, because there's few experts out there on the marketing of estate planning services outside of law firms. So that's what I want to capture here. If you're interested in hearing more, look for my article coming out in Trust and Estates in the April 2021 issue. But long story short, estate planning services are going to continue to grow on the wealth management side. So for both attorneys and for financial advisors, it's better to be proactive than reactive. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.